Hello and welcome to lecture 2 from topic 6. And in this lecture, we're going to be taking a look at abortion policy. Today, abortion is a very heated political topic. You can see from the pictures there that, annually there are pro-life marches and pro-choice marches in Washington, D.C. A lot of voters are, the issue of abortion is probably one of their main issues, and they will vote for president based on who the president will put on the court, whether or not the president will put somebody on the court that will overturn Roe v. Wade or will keep Roe v. Wade the law of the land. This has not always been the case. Until the mid part of the 19th century, abortion was not a politically salient issue. It wasn't, as we'll find out in a moment, really the subject of state statutes or federal statutes. The divisiveness of the abortion topic is really a product of two things. It's a product of the decision by the Supreme Court in 1973 to constitutionally protect women's right to have an abortion. And that's coupled with the entry of the Christian right into partisan politics starting in the 1980s. In our last lesson, we talked about how women started voting with the Democratic Party in the 1980s, in part because the Republican Party aligned themselves with the Christian right. Evangelical Christians used to sit on the sidelines. They didn't want to get involved in politics. I think I'd mentioned that before. Well, after the passage of Roe v. Wade, that changes. And it also changes the political dynamics of abortion policy in the United States. So the phases of abortion policy really mirror the same phases as contraceptive policy. Much like with contraceptive policy, in the first phase of the policy, abortion is considered a private matter. Again, it's the sense of separate spheres. There's a public sphere that's dominated by politics and men, and there's this private sphere, which is the sphere that is dominated by women. And so up until the mid part of the 19th century, abortion is really considered a private matter. That changes after that, very similar as we saw with contraceptives. That we see the rise of doctors as a licensed profession. And so we see that abortion, much like contraceptives, becomes a public matter and is subject to criminal law. And that goes from 1850 to the 1960s. And the third phase is that abortion is constitutionally protected, but with limits. So let's look at each of these phases in a little bit more detail. So prior to 1850, abortion was mostly legal, private, and unregulated. And that's because most pregnancies and the termination of pregnancies were handled in a private domain. It was handled with women, with other women, and there were methods of terminating a pregnancy that were handled with women and their midwives. And that was reflected in law as well. The understanding of conception and fertilization was limited up until the middle part of the 19th century. And what we did know was that you could feel when somebody got pregnant, you could feel when the fetus would start moving. And that was known as quickening, right? So there was a sense that life maybe didn't begin at conception because we had limited understanding of fertilization. But we knew that life was taking place when you could actually feel the fetus moving about. And so terminating pregnancy before quickening, the movement of the fetus, was legal in most states. Post-quickening, it was illegal, okay? So even though it was in the private realm, right, that, there were laws on the books. Most of these were laws based on not statutes that were passed by the actual state, but it was based on common law. What that means is it would be based on how the courts ruled in cases where somebody was brought to court for terminating a pregnancy. And so it was based on common law and custom, not widespread adoption of criminalization of abortion. And even these common laws were rarely enforced by the courts. Again, it was seen as sort of a private realm. And so it was a relatively terminating a pregnancy, particularly pre-quickening, was a relatively common procedure, and it was viewed as a part of a woman's life. And in fact, the first abortion statutes were poison control laws, sort of that it was known that people would take certain substances in order to terminate a pregnancy, and it was these laws were not about criminalizing the act of abortion, but making sure that the liquids that you were ingesting to terminate a pregnancy would not end up in ending your own life. Okay, so much like contraceptives, abortion was until the mid part of the 19th century viewed as a relatively private matter. Um, that changes in the mid part of the 19th century, where abortion enters into the public domain, and when it becomes a public matter of concern, then states begin passing laws criminalizing abortion. So in the 1850s, we see a shift towards viewing abortion as a not a private act or not an act of like private everyday lives of women, but rather it was viewed as a criminal act. And so why is there this shift in terms of in terms of policy as it relates to abortion? Well, a lot of it had to do with the raising concerns regarding harm. We had a lot more by the middle part of the 19th century. We had a much better understanding of conception and fetal development, and so issues were raised regarding the harm that the fetus would be subject to in the process of abortion. Furthermore, so there was concerns regarding harm to the unborn, and those concerns worked their way into the public arena. There was also the professionalization of medical doctors, and so the American Medical Association and physicians. There was a whole process of licensing doctors and making sure that they were subject to professional standards. And that group grew in political power in the United States, in large parts because of, again, a concern with harm. That as you have a licensed professional class, there were concerns about the harms that would come about from non-licensed practitioners. Now, interestingly enough, a lot of the licensed, or most of the licensed doctors were men. As we know, and as we'll learn in the future, that women could be discriminated against on the basis of sex as it came to applying to medical schools. So there were less women doctors at this time, but there were a lot of women midwives, and midwives were unlicensed. And so, yes, there was a concern about harm, that wanting to not have unlicensed people engage in acts that could be harmful, but in a way it was also sort of taking away a livelihood, and also diminishing the expertise of midwives that have been dealing with pregnancy and contraception for a long period of time, and they were sort of displaced by the growing professional class of medical doctors. But again, this sort of shows this trend towards bringing the issue of abortion into the public realm. There was also a differentiation that you'll read about in your textbook between the development of therapeutic abortions and criminal abortions. And so that and that decision was sort of left to the medical class. Doctors would decide whether or not a pregnancy should be terminated for medical reasons, like harming the health of the woman, or other sort of therapeutic reasons. And so there was sort of a distinction between people were getting abortions because it wasn't necessarily a threat to their lives, but they wanted to have an abortion in order to not, have another baby. Those were the abortions that were targeted to be criminalized, whereas therapeutic abortions that were controlled by the medical class were seen as part of a medical practice. So laws, initially abortion laws, focused on illicit preventing illicit practitioners, those who were engaging in abortions either without a license or engaging in abortions as more of an elective process, that there were laws that were targeted at cracking down on those individuals. There were also laws cracking down on the advertising of abortions as well. And so that kind of gives you a sense of the direction of the phase 2 of abortion moving into the private or the public sphere. So as we move into the 20th century, for the first half of the 20th century, that we see that abortion is still a public matter, and for the most part, it is criminalized. So by 1950, it's very difficult to obtain an abortion in the United States. Most states have laws allowing abortions, but only in the case of saving the life of a mother. And so if bringing the pregnancy to full term or any part of term of the pregnancy would result in the death of the mother, then you can get an abortion. But for all other reasons, all other types of abortions were criminalized for the most part in the United States. You also needed to obtain a doctor's approval for an abortion, and that was very difficult to obtain. And particularly because doctors were really worried that they would be prosecuted if they could not demonstrate that bringing a pregnancy to term would result in the death of the woman. And so obtaining a doctor's approval for abortion was very difficult due to the fear of criminal penalties. Well, so what are the impact of these restrictive abortion policies? Well, women still get abortions, okay? But it is difficult to get an abortion, and so an unregulated sort of black market for abortions develops. And these are abortions that take place in very dangerous conditions. Plus, that you had to wait to get an abortion because it was difficult to obtain an abortion in these unregulated environments. And the longer you wait to get an abortion, the more difficult that abortion is and becomes more life-threatening or to the woman getting the abortion. And so that's sort of the pre-Roe conditions in the United States, that a higher risk of death due to dangerous conditions, unregulation, or lack of regulations, and waiting to get abortions. And when you take a look at this graph shows you just how, gives you a sense of the types of abortion statutes that were on the books prior to Roe v. Wade. The white states show that if you lived in a state that was white, that you could only get an abortion if the life of the mother was at risk. In the gray states, that you could, these were some states that made changes to their policies between 1966 and 1970, permitting abortion under certain circumstances, such as pregnancy resulting from rape or incest. Okay. And so that we do see some changes at post 1950, but before Roe, where some states are allowing abortions in some certain circumstances. And then very few states in the black, their state laws allowed for abortion on demand, that you didn't need to have a reason or to get an abortion. Abortion was viewed as an elective procedure. So abortion policy obviously changes significantly in 1970. And it builds off of the decision that was made in Griswold versus Connecticut that we talked about in the previous lecture. So Griswold versus Connecticut establishes the right to privacy as it relates to using contraceptives. What goes on in the privacy of your bedroom is your business. The government doesn't have a right to intrude upon that. And the decision to get contraceptives is a private decision between a couple or a single person and their doctor. The question is, coming out of Griswold, is does the right to privacy extend to abortion? And that question comes before the court in Roe v. Wade. And the answer to that question is yes, the right to privacy does extend to abortion. This brings us to Roe v. Wade, the landmark case from 1973. And so let's look at the facts of this case. Now, most everybody knows the case Roe v. Wade, but they might not know who Roe is. Roe is Norma McCorvey, and they refer to her and Roe in the title of this case to protect her identity. Since it was a sensitive subject having to do with pregnancy and abortion, the court will oftentimes use a name like Roe or Doe or the initials of a person's name in order to protect their identity. Norma McCorvey had a pretty tough life growing up. She was born in Louisiana, and her family moved to Texas. That she spent a lot of time as a young person in like a correctional facility for girls. She was in and out of trouble for a long time. Her life was not easy. She becomes pregnant early in life and has the child. She develops a drinking problem and it is just really facing a lot of challenges. And so by 1969, she gets pregnant with her third child. So she has two children, and then she is pregnant with her third child. And she doesn't want to she does not want to carry this pregnancy to term, just given the circumstances of her life. She claims that she was raped. She worked as a carnival worker, and she was claimed that she was raped. That wasn't true, but she thought it might be easier for her to get a doctor to consent to giving her an abortion. So she went to a doctor in Texas, and the doctor refused to give her an abortion because in Texas it was a crime to give somebody an abortion, to perform an abortion on somebody if their life was not at risk, and her life was not at risk. And so Norma McCorvey felt that was unfair and that it violated her personal rights of privacy. And so she works with, there were attorneys to bring this case to the Supreme Court to make the argument that denying a woman the right to have an abortion is a violation of her right to privacy, that it's her body. And just like with contraceptives, that getting an abortion is a private matter that should be made between a woman and her doctor. And so that's the question that was before the court. Does the Texas law violate a woman's right to privacy? And the answer in the case is yes, it does. So in a 7-2 decision, the court answers the question about whether or not prohibiting or criminalizing abortion violates a woman's constitutionally protected right to privacy. And they say that it does, that the right to privacy exists and that it includes the right to choose to have an abortion. That women have the freedom and privacy to decide whether to terminate their pregnancy. In Roe v. Wade, they found the right to privacy in the Due Process Clause of the 14th Amendment. We don't need to get too caught up on that. But do remember that in Griswold, they found the right to privacy in the combination of the First, the Third, the Fourth, the Fifth, and the Ninth Amendment, right? Well, in this case, they find it in the Due Process Clause that says that you cannot take away a person's life, liberty, or property without the due process of law. And that liberty was construed as being broad enough to cover the right to privacy. And so they said that is where they found the right to privacy. Now, keep in mind that what's interesting about Roe is that Roe sets a framework. It's called the trimester framework for when a woman can get an abortion. And also when the state can start impinging upon a woman's right to privacy. Okay, so it's sort of like earlier in the pregnancy that the individual has unfettered rights to seek and obtain an abortion. So as it says there, that early in the pregnancy, in the first trimester, the first 3 months, the government cannot criminalize abortion. Okay, and so the thinking is in that first trimester it was prior to viability. But as the pregnancy progresses, the state can increase its regulations. And so when you enter into your second trimester, that the state can have more regulations in terms of what might constitute a legal abortion. And in the third trimester, when the fetus is could live on its own outside of the woman's body, in the third trimester, it allows states to prohibit abortions altogether. And so Roe is saying that you don't have this unqualified right, or Roe isn't saying that you have this universal right to have an abortion whenever you want to have an abortion. It's basically saying that as the pregnancy goes on, the interest of the state increases and the state can begin to regulate and prohibit abortions as the pregnancy moves closer to the ninth month. Okay, so Roe v. Wade establishes a woman's right to a constitutionally protected right to have an abortion. And so after Roe, we really begin to see the political lines being drawn. It's after Roe that abortion becomes a driving political issue. And we see the rise of the pro-life movement. And we also see the rise of the pro-choice movement as well. The pro-choice movement is excited that the court rules that women have the right to an abortion, and they create groups, pro-choice groups like NARAL, that work on protecting that right. The pro-life movement develops in order to challenge the decision that's made in Roe v. Wade. And so when you look at the long-term goals of the pro-choice movement is to keep abortion safe and legal. The long-term goals, though, of the pro-life movement are to get the court to reconsider Roe and overturn it. And that continues to be the long-term goal of the pro-life movement. Their short-term goals are that if you can't overturn Roe, then what are we going to do in the short term? And their short-term goal has been to increase restrictions on abortion, thus making abortions more difficult to get. And so you'll read in the textbook that after Roe v. Wade, states passed laws making it more difficult to get abortions, where you might need to have a waiting period of 24 hours, where there would be certain regulations that abortion clinics would have to abide by, that you would have to get the approval, if you were a minor, of your parents or approval of your spouse, which was deemed unconstitutional in Casey. But that was sort of the whittling away approach that the pro-life movement took, make it more difficult, less accessible, and at some point, Roe v. Wade will ultimately be overturned. So where are we today on abortion policy? Well, Roe v. Wade is still the law of the land. It still is. You still have a constitutionally protected right to have an abortion. But since Roe v. Wade, there have been several cases that have changed the way the court approaches abortion rights. You'll read in the textbook about the Planned Parenthood v. Casey case that establishes a new standard to determine whether restrictions on abortion are unconstitutional. Under Roe, it was used the trimester framework. The closer the pregnancy came to term, the more the state could restrict a woman's access to abortion. In Casey, there's a new way of thinking about the restrictions. The new way is called the undue burden test, and that's the law of the land today. The undue burden chance basically looks at restrictions on abortion laws, waiting periods, ultrasounds, having to read a manual or pamphlet before you get an abortion, etc. They look at those laws and they ask, do these laws place a substantial obstacle in the path of a woman seeking an abortion before viability? Because after viability, right, Roe sort of is still the law of the land, that you can have restrictions on abortion post-viability. But before viability, can you have regulations there? Well, the court says yes, that as long as those regulations are not posing an undue burden, then those restrictions are allowable and constitutional. And that's sort of where we're at today. Where we are at today is where we are seeing many cases come to the Supreme Court that are looking at the restrictions that are placed on abortion clinics and asking the question, do these present a substantial obstacle to women getting an abortion? Now, as we know, waiting periods and informed consent and getting a minor needing to get the consent, ultrasounds, those sorts of things have all seen as being not presenting an obstacle, a substantial obstacle for women to get an abortion. But recently there have been a couple cases that have come to the Supreme Court. One was Whole Women's Health v. Hellerstedt in 2016. And just this summer, there was the June Medical Service v. Russo case. Both of those came to the Supreme Court. And those had to do with about admitting privileges that people work in and give abortions in an abortion clinic, whether or not they have to have admitting privileges at the local hospital. Also, making sure that abortion clinics have like really wide hallways so that you can get like an ambulance stretcher through them, etc. And when these kinds of like admitting privileges and other regulations have been put in place in states like Texas and Louisiana, a lot of abortion clinics could no longer function because that they weren't able to meet those standards. Well, the Supreme Court actually said that the admitting privilege standards and the ambulatory hallway standards actually did present an undue burden on women seeking an abortion, and those kinds of regulations were deemed unconstitutional. So the whittling away at Roe, and we'll see where that kind of goes in the future. However, I have the picture there of Amy Coney Barrett. She's the judge who is being, as we speak, questioned by the Judiciary Committee of the Senate. She's President Trump's pick to replace Justice Ruth Bader Ginsburg. And I think there is a lot of people who think that given both Judge Barrett's judicial philosophy as well as her personal perspective on abortion, that there's a lot of concern or excitement that a case will come to the Supreme Court and that the Supreme Court will overturn Roe v. Wade. Basically that Roe v. Wade, the constitutionally protected right to an abortion, would no longer be the law of the land. And so we'll see whether that's going to happen or not. We really don't know. Today at her confirmation hearing, she talked a lot about the importance of stare decisis, which is basically saying that precedents really matter. And that, she didn't say this, but, Roe v. Wade is settled law. It's been on the books for nearly 50 years. And so what one would maybe think that if she's speaking so strongly about the importance of abiding by court precedent, that she would not she would not decide to overturn Roe v. Wade. And so we'll see. We'll see what happens. Another question is what if Roe is overturned? Well, what would that mean? Well, if Roe is overturned, it would just mean that, not just, but it would mean that you didn't have a constitutional right to an abortion, but your state would get to set your abortion laws. So sort of like that graph that we looked at before, where some states in 1960s allowed you to get an abortion on demand, and other states only if the life of the mother was in jeopardy. That's basically what it would look like if Roe v. Wade was overturned. So stay tuned. We're not sure what the outcome of this will be, but it is obviously an incredibly timely issue. Thanks a lot for listening, and I will talk to you again soon.